Hi everyone, today we will do legal dictation exercise number 41. So, ready? Start. On an careful reading of the aforesaid paragraph of the election petition contained in Annexure 1 of the writ petition, it is clear that election petition contains an adequate statement of all material fact on which the allegation of not only illegality in counting of votes were founded but specific allegation of manipulation and fraud played by returning officer while counting of votes were labeled with material particulars. Not only this, but the petitioner had also adduced voluminous evidence to support the allegation leveled in the election petition in respect of aforesaid illegality and manipulation in counting of votes by entering himself in witness box and by examining his counting agent. The aforesaid version of election petition was also supported by the other candidate by filing their affidavit before the election tribunal, which clearly established that the petitioner had adduced sufficient evidence affording a good ground for believing that manipulation was done and fraud was played while counting of votes by returning officer, and therefore, in my opinion, the only way to decide the dispute and to do complete justice between the parties was order for recounting of vote. From the perusal of impunged judgment and order passed by the election tribunal, it appears that the statement of petitioner and his agent in respect of manipulation in counting of votes has been rejected without any cogent reason. It appears that while dealing with issue, the election tribunal under wrong notion of law has illegally amused that the petitioner was required to prove his allegation made in the petition beyond reasonable doubt. Area in view of legal position enunciated by Honorable Apex Court, and this court from time to time has indicated herein before such standard proof for inspection of ballot paper for the purpose of recounting of vote is not at all necessary. The election petitioner was required purely to adduce such evidence on the basis of which allegation could be prima facie established, affording good ground for believing that there has been mistake or illegality or manipulation in counting of votes, and further on the basis of such evidence court or tribunal trying the election petition could be prima facie satisfied for directing inspection of ballot paper for recounting of votes. A distinction between prima facie opinion and concluded opinion was required to be kept in mind, but while rejecting the prayer for recount of votes, in my opinion, the election tribunal has proceeded completely on wrong notion of law and rejected prayer for recount of votes on the ground that the petitioner has failed to prove his case. In this connection, it is to be noted that when the allegations in the petition were not vague or indefinite or frivolous, rather they were specific in terms and support by oral evidence adduced before the election tribunal, inasmuch as affidavit of the other candidate there were sufficient material before the election tribunal affording good ground to believe that illegality or manipulation was done on counting. Thank you. Please subscribe my channel Steno Star.